All right, so that intro matter out of the way, let's talk a little bit more about our session for today. So, welcome to the Title II and You, What Do the Updated Digital Accessibility Rules Mean to You session. So, I'm Phil Deaton. I'm our Deputy ADA Coordinator for Digital Accessibility in the Disability Equity Office, which is part of our Equity, Civil Rights, and Title IX office. So with me today is my colleague, Jessica McQuaig, who's a senior digital accessibility specialist here with DEO, and will be your presenters today. So thank you for joining us.
Before we get into today's content, here are some quick Zoom webinar tips. First, please use the Q&A feature to submit your questions, and you'll find that in the toolbar at the bottom of your Zoom screen. ASL interpretation can be utilized by clicking Interpretation and selecting American Sign Language, and you might find that button under the More button in your Zoom toolbar. Cart transcription is also available and can be turned on by selecting Show Captions. A version of this workshop has been recorded and will be made available on ECRT's YouTube channel, and that will be available as soon as possible. The link to that is youtube.com/@ECRTUMISH. The slides will be emailed to all registered participants within the coming days, along with a short anonymous survey. We do encourage you to complete the survey, as this will help us determine how we can best meet your learning needs into the future.
All right, so let's go into our agenda for today. Again, these workshops are part of our series here for NDEAM. And with the Disability Equity Office's workshops, we really try to center ensuring that the needs of individuals with disabilities are prioritized, and that all members of our diverse community have access. So today we're going to dive into why digital inclusion matters. We're going to talk about the Disability Equity Office's role in digital accessibility. And then we'll give a brief legal framework of Title II of the Americans with Disabilities Act, especially highlighting the digital accessibility aspects. Then we'll talk a little bit more about what does digital accessibility mean in today's context. And then we're going to end on talking through the Title II regulations, including what is covered and what are some of the exceptions under Title II. Subpart H is the new subpart for digital accessibility. We'll have a little bit of time at the end to go through some of the questions that come up through the Q&A feature, and we'll also try to monitor the Q&A feature as we're going through the presentation today. So please do feel free to ask your questions via that feature.
As we move through the content today, we do encourage you to engage with us via that Q&A function. We'll get to as many questions as we can during today's presentation, and we'll follow up via email for any questions that we don't have time to cover. Please remember that we are all lifelong learners, including me and Phil, and we're all at different levels of knowledge. So we should respect that everyone is here to gain new insights and grow as a professional.
All right, so before we get started, we did want to start with a few basic acronyms that we'll be using throughout today. So the first is ADA for the Americans with Disabilities Act. The second acronym is EIT for Electronic and Information Technology. The third acronym is IWD for Individual with a Disability. And then the fourth acronym, and you may hear us refer to this acronym in a few different ways, is WCAG or WCAG, which is short for the Web Content Accessibility Guidelines, which is an international set of digital accessibility guidelines that really help inform our requirements.
So today we'll be discussing updates to Title II of the Americans with Disabilities Act, which are focused on digital accessibility. While this is a compliance matter, the reasons to care about digital accessibility go beyond compliance. We are not just here to check boxes. At U of M, our goal is disability inclusion and, in this case, digital inclusion. An impactful quote that is relevant to thinking about this work is by Haben Girma, our upcoming keynote speaker, who is a human rights lawyer, disability advocate, and the author of Haben, the deafblind woman who conquered Harvard Law. Haben says people with disabilities succeed when communities choose to be inclusive. As the new regulations make clear, digital accessibility is the responsibility of everyone in our community. So, what do we mean by digital inclusion? Digital inclusion means all users, regardless of disability, have equivalent access to digital tools and interfaces. While accessibility is an aim of digital inclusion, it extends to considering the whole user experience, including how efficient and usable electronic and information technology is for a wide range of users. It is about improving digital experiences for all of us, not just about meeting a technical requirement. Unfortunately, and perhaps not surprisingly, we continue to have a digital divide, which defines the gap between those who have access to and can use digital technologies and those who do not have access and cannot use them. Individuals with disabilities, who make up 28.7% of American adults, are more likely than individuals without disabilities to be on the disadvantaged side of the digital divide. This contributes to other gaps between individuals with and without disabilities, including the education gap, the employment gap, and the information gap. This is illustrated by the annual WebAIM Million Report, which assesses the accessibility of the top 1 million websites against WCAG criteria. Although there have been slow improvements, in 2025, only 5% of assessed websites met WCAG Level 2 criteria or version 2 criteria. 94.9% of the websites examined pose accessibility barriers to people with disabilities. To narrow and eventually eliminate this digital divide, it will take all of us working together. As leaders in BEST, we know this community has what it will take to make a significant positive impact in this area.
All right, so next we're going to move into talking a little bit more about the Disability Equity Office's role in digital accessibility compliance. So before we discuss the compliance aspects of the Title II updates, we want to provide some information about the role our office plays in digital accessibility across the university. As we examine the updated regulations, we want to ensure you know how our office can help and what role we play. So a little bit more about DEO and some of the roles in our office. Firstly, the ADA coordinator is statutorily responsible for oversight of disability-related complaints and grievance processes, and is responsible for coordination of efforts and compliance across the organization with the ADA and disability-related federal and state laws. The ADA coordinator also serves as a subject matter expert for these various aspects of disability and accessibility. So next, we're going to talk a little bit more about the digital accessibility group within DEO. So we provide digital accessibility training, accessibility review, and guidance for procuring accessible software and applications. We also are responsible for oversight of the Electronic and Information Technology Accessibility Policy, which is SPG 601.20. And sorry, SPG stands for Standard Practice Guide here at the University of Michigan. We also serve as subject matter experts on digital information accessibility. We do a lot with different technologies and thinking through accessibility ramifications, and we're here to help if you have any questions. And lastly, we respond to reported digital accessibility barriers that may come up, and we do a lot of work in that area. So I'm going to go ahead and advance to the next slide.
So now we'll briefly explain some of the fundamental aspects of the legal framework that Title II is a part of, and we're going to discuss the Title II updates specifically. Title II is a part of the Americans with Disabilities Act, or ADA, which was first signed into law in 1990 and then substantially amended in 2008 to clarify the definition of disability as well as the responsibilities of entities covered by the law. The ADA prohibits discrimination and harassment against individuals with a disability in regard to their employment, access to public places, participation in public education, and beyond. There are four main sections called titles within the ADA that cover these different areas and the different types of organizations that have responsibility under the law. Title I covers employment. Title II covers public sector entities, including state and local governments, as well as organizations that receive public funding, such as schools, and this includes higher education institutions. Title III covers public places, and specifically, these are owned, operated, or leased by private organizations which offer goods and services to the public. And finally, Title IV covers telecommunications, specifically measures to support hearing impaired and speech impaired individuals. It's important to know that the ADA is just one law that aims to protect individuals with disabilities from discrimination and provide equal access. There are additional laws at the federal, state, and local levels, including the Federal Rehabilitation Act of 1973, the Fair Housing Act, and Michigan Persons with Disabilities Civil Rights Act. We are not covering these laws today, but it is important to know additional regulations impact the accessibility legal landscape. So, what is disability? The ADA defines disability as a mental or physical impairment that substantially limits one or more major life activities. Substantial limitation in this case is determined by comparison to an average person in the general population. Major life activities may include any of the following: bending, breathing, caring for self, concentrating, hearing, interacting with others, learning, lifting, sitting, speaking, standing, thinking, walking, working, and beyond. This includes people who have a record of such impairment, even if they do not currently have a disability. And disability also includes individuals who do not have a disability but are regarded as having a disability.
So what does Title II cover? The Title II of the Americans with Disabilities Act is designed to ensure that state and local government services, including public universities, are accessible to people with disabilities. This means that all digital content, like websites and mobile apps, must be designed so that everyone can access them regardless of ability, disability, or use of assistive technology. Subpart H of Title II is the newly updated section and includes greater detail and clarification about public entities' role in providing digitally accessible content. Following up on that, what was the purpose of these updates to Title II? For many years, disability and accessibility advocates, as well as many state and local governments, were very frustrated by the lack of clarity around digital accessibility under the ADA and the differing standards nationally and at the state level for designing web content and digital content in general. The purpose of the updates to Title II are to ensure that state and local government services, including school and university websites, mobile apps, and digital information, are accessible to individuals with disabilities and are consistently accessible to individuals with disabilities. And also, they are there to provide clearer guidelines and standard technical standards for making digital content accessible to everyone. So, what were some of the major Title II changes? The new updates to the regulations are not the full makeup of Title II of the Americans with Disabilities Act. As I mentioned earlier, it's just a more defined subpart, Subpart H. Subpart H of Title II requires use of the Web Content Accessibility Guidelines 2.1 AA standard, and it applies to web content and mobile apps that public entities provide or make available, whether that's making it directly available or through contractual, licensing, or other arrangements. Subpart H does not detail requirements for desktop applications. However, it's important to note that those applications that support our services, programs, and activities still need to be considered under digital accessibility requirements. So there are two compliance deadlines that are listed in the regulation update. One is for April 2027, and the other is for April 2026. Large entities have to meet the April 2026 compliance date, and size is based on the population served. The University of Michigan is a large organization based on the information provided in the regulation update, and therefore we must demonstrate compliance with the new Subpart H of Title II by April 24th, 2026.
So, the final concept to discuss before we move into specifics about how Title II applies to you and the University of Michigan is digital accessibility. Digital accessibility means that EIT and experiences can be accessed, participated in, understood, and made use of by all. In this context, accessibility is not referring to whether something is available or easy to attain. In this instance, accessibility means individuals with disabilities can effectively and equitably engage with EIT without facing barriers or burdens as compared to individuals without disabilities. This is achieved by implementing technical standards and best practices that center the needs of individuals with disabilities. Next, we'll talk about WCAG 2.1 AA. So, the Web Content Accessibility Guidelines, known as WCAG, are a technical standard provided by the World Wide Web Consortium, which also goes by W3C, which is an international organization that sets standards for web stewardship. WCAG criteria are designed with a range of accessibility needs in mind. Each version accounts for a broader range of user needs, and each level offers a progressively more robust level of accessibility. So, level A is the bare minimum. Level AA provides good accessibility to the widest range of users, and level AAA addresses needs that are less common but still important. WCAG includes design principles and guidelines and specific testable success criteria to meet. As noted, Title II updates and U of M standard practice guidelines require adherence to WCAG version 2.1 level AA criteria, which we'll touch upon momentarily. Please note that while WCAG is a widely used standard for digital accessibility, it does require some interpretation. This is especially true in relation to how standards apply to the variety of digital tools and formats that continue to emerge as technology evolves. You can contact the Disability Equity Office for guidance where needed. So, the University of Michigan and community members who develop and distribute EIT on behalf of U of M have had digital accessibility obligations under the ADA and Sections 504 and 508 of the Rehabilitation Act prior to this Title II update. These obligations were already being enforced by the Federal Department of Education's Office of Civil Rights, the Department of Justice, and Health and Human Services. As discussed earlier, new regulations aim to provide needed clarity on the standard, expectations, and scope for digital accessibility. They also set deadlines by which covered organizations should be in compliance with the clarified standards. As a reminder, our deadline, April 24th, 2026, necessitates that we work on meeting these standards rapidly. Arguably, the most impactful clarification under Title II updates is that password protected course materials are within scope. Previous stances on whether course materials behind a login were covered had varied by institution. Many relied on a reactive approach to addressing course related accessibility needs. In other words, meeting needs through case by case disability accommodations. We now know we need to take a proactive approach to at least meet the defined standards. That said, we are still obligated to provide reasonable accommodations and access in cases where individuals with disabilities have needs that exceed the minimum standards. It is important to consult with the Disability Equity Office before determining a request that exceeds these standards is unreasonable. We are also responsible for ensuring that third-party EIT used on our websites, in our courses, or in the delivery of other U of M programs and services is compliant with the standards. You can consult the Disability Equity Office for assistance determining whether a third-party product or service is compliant. There are some exceptions to these new regulations, and we'll review those later in this presentation.
So next, we'll discuss the types of digital content covered by WCAG criteria in the Title II update. For all these digital content types, guidance on best practices and tools to assist with digital accessibility work are available on the digital accessibility website for UM, which is accessibility www.umich.edu. Okay, so firstly, we'd like to talk about websites, web applications, and web content. These must be accessible. This does include web-delivered content, including documents you may post to your website. So let's talk about how this affects different individuals here at UM. For web developers, you may need to consider the accessibility of your web templates, platforms, and any third-party tools you're using. Remember, third-party widgets are not exempt. If it is inaccessible, you can work with the supplier that you're working with or work on the changes for open source products. Otherwise, you may need to seek an alternative product. We must also consider content accessibility. Thousands of people create new web content for the University of Michigan every day. This content must be accessible per the Web Content Accessibility Guidelines 2.1. And we all have a part to play in creating accessible content. So we think that units may need to consider broader training for web content creators around digital accessibility. It's important to note that the University of Michigan's Information and Technology Services unit does have a web accessibility scanning tool and service, and they're working to roll out a new tool to replace our pre-existing web accessibility scanning tool. So we've got some links on the slide right now that you should be able to access, which go to the accessibility website. In relation to website accessibility, we wanted to talk a little bit more about some of the top WCAG failures that were reported in the previously mentioned WebAIM Million report. So just to go into them briefly, some of the most common web accessibility failures that we saw were around low contrast text. So this just means low contrast existing between the text color and any background colors that are behind that text. We also saw issues around missing alternative text for images. So images that lack alternative text will be inaccessible to a variety of users, including blind and low vision individuals who may use tools like screen readers. Two additional ones we saw were around missing form input labels and empty buttons. These elements not being programmed correctly can impede or totally prevent users with disabilities from filling out form fields or applications, so ranging from basic search elements or required web forms that we need to utilize for various University of Michigan services. Another common issue that we had was around empty links. So the WebA Million report references that empty link text impacts users with and without disabilities by making it challenging to discern what will happen when a link is selected. So if you click on a link, where are you going to be taken to? And then the final one that was mentioned as a top WCAG failure is missing document language. So not defining the language of a web page may prevent access for users of certain assistive technologies. So we always need to be cognizant of that.
Next, we'll explore how the Title II criteria apply to documents. So, documents do generally need to be accessible unless an exception applies. And again, we'll discuss exceptions later in this presentation. And this includes documents that you digitally distribute. That could be via email or posting to university websites, courses, or social media accounts. And this is regardless of whether or not you created the documents. So what we recommend is use available accessibility checkers to improve document accessibility. And this can include the accessibility checker that's available through the Microsoft Office suite, as well as Grackle in the Google Office suite. We recommend avoiding PDF as a format where possible. PDFs are notoriously difficult to make accessible, and when converting to other formats to PDF, any accessibility work that you've done on the source file may be lost. We also recommend sticking with original document formats wherever possible. So this may include Word format, PowerPoint, Excel, or Google Docs, slides, or Sheets formats. In these cases, you can set the files to read or view only to deter editing, and you can mark them as final if you're in the Microsoft suite. You can also password protect files where necessary. And in fact, this provides a higher level of protection against editing than in the PDF Adobe environment because everyone at U of M has access to Adobe Creative Cloud, which allows direct editing and resharing of PDFs. So they're not as secure a file format as we once believed that they were. So course content is also covered in a deeper way than we previously understood it to be. So as noted, we now also need to make course materials proactively accessible. This includes materials that are password protected or behind a login, so files that you might find in Canvas courses and other course management platforms. In addition to course pages needing to be accessible, the materials uploaded to, linked within, or embedded into those pages also needs to be accessible. This includes documents, slide decks, video and audio content, etc. Panorama is a new tool that was launched in 2025 to assist with both scanning and remediating Canvas course materials to meet accessibility standards. So please utilize Panorama for your courses in Canvas. Complex content, such as STEM materials, may be more challenging to make accessible. If you're dealing with complex materials and need assistance, please reach out to the Disability Equity Office for guidance where needed. And remember that reasonable accommodations may still be necessary even if all of your course content meets the minimum standards in the Title II updates. Next, we'll discuss how the criteria apply to media. So, media refers to video and audio content, and that is whether it is pre-recorded and uploaded to a platform like MyVideo or YouTube, or content that is live streamed through a platform like Zoom. Features that make media accessible include captions, transcripts, audio description, and sometimes sign language interpretation. The Disability Equity Office offers services to assist with media accessibility, including a communication access in real time or CART fund, and essentially this is funding to support live captioning at events, as well as American Sign Language or ASL interpreters. The link that's provided in the slide deck will connect U of M community members, students, and employees to more information about these services and guidance on how to request them. Digital applications are also covered under the new criteria. Digital applications may also be referred to as software as a service, and these are effectively digital interfaces that allow people to engage with U of M programs, services, activities, and content. So this includes those digital applications that are created, used, or purchased for internal use, as well as those that are external facing for students, prospective employees or patients, members of the public, etc. These include applications that support online purchases, such as event tickets and parking passes, employment portals and forms, such as our job applications or benefits applications, academic programs, including our course portals and Canvas learning tool extensions, our public education programs. These could include things like virtual museum tours or our massive open online course platforms. Our library services are covered, such as our collections interfaces, health services tools like MyChart, as well as research tools, including survey platforms and data collection tools.
So one question we've received a fair bit, given the vast breadth of the new regulations, is we how we handle large amounts of archived materials. So Subpart H of the Title II regulations includes a new definition for archived web content, and that definition may differ a little bit from how universities define and use the word archival. So one thing that we'll just note before we jump into the exceptions is that we cannot assume materials are archival in nature unless we can work through the archival web content analysis, which we'll talk about in the exceptions. But if you have some of these large batches of content on your website and you're really unsure how to proceed, we really recommend reaching out. And of course, these new regulations do ask us to consider complex issues around how we manage and govern our websites and how we think about what we put on those websites. So we need to really be strategic about that. So since we've mentioned the exceptions, I think at this point it's time for us to go ahead and move towards some of those exception areas. So we're going to go ahead and move that way. So subpart H of Title II does introduce various exceptions and frameworks, and we'll discuss how we can utilize those. So we do want to give a caveat that we have to bear in mind that many structures around these exceptions are untested. So we are providing the university's best sense of how those exceptions are applied today. And this may change as we see more litigation or more informative documentation from our regulators over time. Okay, so what are the exceptions for Title II compliance? There are five main overarching exceptions, and we'll provide some more detail on each. But again, reach out to DEO if you're curious about whether this may apply. So the first exception is for archived web content. The second exception is for pre-existing conventional electronic documents. The third exception is for content posted by a third party. The fourth exception is for individualized, password protected, or otherwise secured conventional electronic documents. And by the way, don't worry, we're going to go into the definitions for each of these in great detail. Um, and then the next exception is for pre-existing social media posts. So a couple things to note before we move into these exceptions. First, if a document or a web page meets these exceptions, you still need to provide reasonable accommodations and access to these documents when people with disabilities need them. So you should be sure to have a process in place for thinking through how you could do that in a timely fashion. Secondly, anytime we're making a case for an exception for under Title II, we should really be documenting these decisions so we can demonstrate our logic and our decision-making process. And last, and this applies to all of them so that I don't reiterate this too often throughout this next section, is please reach out to the Disability Equity Office as you consider eligibility under the Title II exceptions. All right, so we're going to move into the first exception area, archived web content. So the first exception is for archived web content. And it's important to note again that the federal government's definition for archival in this context differs pretty significantly from how we in post-secondary education institutions may think about archival. So in the past, this has been discussed as legacy content by the federal government, but really archival content under these new regulations is pretty narrow, and it's likely not something that we can expect to receive an exception for our archives that we maintain. So these are archive services that may be run through various different services here at the University of Michigan. Because we are oftentimes creating these to promote historical discourse as a program, activity, or service in connection with what's going on today. So this archival web content exception is more so designed to provide a way to push superfluous or outdated content into an archival area, provided it meets the following analysis. So for something to be considered archival web content under this exception, it must meet all four of the following bullet points. Firstly, the content has to be created before the effective date of compliance or reproduce paper documents or physical media that was created before that effective date of compliance, which again for us is April 24th, 2026. Second, the content needs to be kept for reference, research, or record keeping. Those are the only viable reasons that they could be kept for and considered archival. Third, that content must be kept in a special area for archived web content. And then fourth, that content cannot be changed after it is archived. So it's important to note that the ways to define a special area for archived content are really not fully defined in the regulations. So we're trying to track that conversation nationally to see what other people are promoting and seeing what seems to be an appropriate practice for this. There are several methods that have been discussed, such as having an archived section on a website or labeling and tagging information as archived. So the next exception under Title II is for pre-existing conventional electronic documents. So let's unpack that a little bit. What is a conventional electronic document? That is web content or content in mobile apps that is presented in electronic file formats such as PDFs, word processor file formats, presentation file formats, and spreadsheet file formats. And essentially, there's a two-stage analysis here for determining whether or not we can skip making a pre-existing conventional electronic document accessible. And documents that meet both of the following points usually do not need to meet WCAG 2.1 level AA, except in some situations. So let's talk about the two-stage analysis a little bit. Firstly, the document has to be a word processing, presentation file, a PDF, or a spreadsheet file. And that document has to have been created prior to April 24th, 2026, and not used to apply for, gain access to, or participate in a service, program, or activity. Documents that are currently being used to apply for access or participate in a state or local government services or activities do not really fall under this exception, even if the document was posted prior to the date the entity was required to comply with the rule. And again, that date for us is April 24th, 2026. So the next exception that we're going to talk about is for individualized password protected documents. So there's another exception for documents, and there's a couple of things that must be true in order to be eligible for this second document exception. Firstly, again, this has to be one of those conventional electronic documents as defined in Subpart H. So a word processing, presentation file, a PDF, or a spreadsheet file. But these next two also have to be true. The document has to be about a specific person, their property, or their account. And then the document also has to be password protected or otherwise secured. So an example that could be appropriate might be a PDF version of an individual student's transcript that is password protected or otherwise secured. However, there's a couple things to note here. If there is a web equivalent, then that web equivalent must be accessible. Next, we've got content posted by a third party. So our next exception for content posted by a third party, it's important to provide a little bit more context for this. If we are contracting with a third party, licensing software or some other content, or have a financial arrangement with that third party, then we still have to make that content accessible. And oftentimes that means having to work with that supplier to make that content or application or web content more accessible. However, if we do not have a contract or an agreement or other arrangement with that third party, we actually can use this exception. So where this could be applicable here at is for content that is posted by community members to our social media, discussion boards, or various different other areas where we allow for public comment. Okay, our next broad exception area is for pre-existing social media post. And this is another exception that we really cannot use too much after April 24th, 2026, the pre-existing portion. Many folks have already been doing a lot of work to make their social media posts accessible. So while this is an exception area, we do recommend uh, trying to continue practices around social media accessibility if we're already doing that work. Additionally, if we create a post prior to April 24th, 2026, and then repost or otherwise re-amplify that social media post, we would need to then make it accessible in order to do that. So if your social media post is not related to a current program, service, or activity and it hasn't been reposted, then we can use this exception prior to April 24th, 2026. I would like to, however, point to a recent civil case out of the Fifth Circuit, which is Ellerby versus the State of Louisiana Division of Administration, Office of Technology Services. This is from January 2025. In this case, the court ruled that the State of Louisiana Division of Administration could not wait until the new Subpart H obligations took effect before responding to various different digital accessibility complaints or requests to make things accessible. So if you're already doing this social media accessibility work, uh, we really do encourage you to keep doing that. The LRB ruling is important, though, for two reasons. Again, it reminds us that prior to the Title II regulation update and the Section 504 regulation update, we already had these laws and regs which had been interpreted as applying to digital accessibility since the late 90s. It also illustrates that we cannot refuse to take action or provide support when people with disabilities um, request that support or need to see things made accessible and say, hey, we'll do that after April 24th. That is not an appropriate course of action. So this is not specific to social media, but it really illustrates the importance of immediate action to resolve those barriers and why we should continue doing this proactive work and really get started on this work now. After April 24th, 2026, there's not a magical switch that is toggled on or off that allows the university to receive a complaint or face regulatory action. Okay, so there are a couple other exception areas um, to consider under Title II broadly. So we'll just talk about these briefly. Again, we'll note that you should always work with DEO for these two exception areas. So the first is an exception for fundamental alteration. So a fundamental alteration is a change that is so significant it would alter the essential nature of the care, service, or experience being provided, significantly interfere with health or safety, or invalidate the objective of the service or program. If you ever think that you have a case for using the fundamental alteration exception, you should reach out to DEO. Same thing with undue hardship, which is any action that would require significant difficulty of expense to the overall resources of the entity or be unduly burdensome on unit operations when considering several factors on an individualized basis. Don't try to make these determinations yourself, though. Reach out to DEO. The new Subpart H has three other general provisions that may be helpful to understand. So first, in some cases, we may use conforming alternate versions of content or services. However, we can only use those in cases where it is impossible to make web content directly accessible due to technical or legal limitations. I'm trying to read that off very specifically because there's a very narrow case in which these conforming alternate versions are appropriate. Conforming alternate versions should never be our first option, and they should really only be used as a last resort. And another thing that we would note here is to remember that accessibility overlays or accessible versions, I'm using air quotes here, of products or content oftentimes provide worse experiences to our users, and they may be hard to maintain if we're trying to maintain two separate versions of content or services. And additionally, we may run many risks in utilizing separate experiences or platforms exclusively for people with disabilities. The second notable principle is that of equivalent facilitation. Essentially, what this says is that in lieu of the Web Content Accessibility Guidelines 2.1 AA, we may choose to exceed those standards or use alternative standards where appropriate. So if you don't think that WCAG 2.1 is the right standard for a specific type of information technology that you're working with, we can use a different standard. But again, reach out to us and we can help you think through how which standards we can apply to that context. And then the third principle here is in subpart H as well, and this is for effects of noncompliance that have a minimal impact on access. And on the next slide, I'd like to conclude with this, as this actually really spells out some of what the federal government expects for public entities. So our regulators basically state that we will be deemed to be compliant with Subpart H of Title II if we can demonstrate that certain access issues do not significantly impact people with disabilities. This section references text that has been used in various different resolution agreements and lawsuits over the years. And it's really a great guide for what our goals should be as an institution, actually. So it spells out that we should ensure that individuals with disabilities can use our web content or mobile app to do any of the following in a manner that provides substantially equivalent timeliness, privacy, independence, and ease of use. So essentially, people with disabilities should be able to access the same information as individuals without disabilities, engage in the same interactions as individuals without disabilities, conduct the same transactions as individuals without disabilities, and participate in or benefit from the same services, programs, and activities as individuals without disabilities. So we think that these principles are really core to this work. Um, and again, that's why we kind of wanted to highlight this section here. But that's the end of our detailed analysis of the regulations. I think it's important to note that the new regulations and our pre-existing obligations apply to a large swath of what the University of Michigan does. And we really hope that this has helped clarify how we can meet some of these new regulations before we dive into wrap up here.
There are no open questions at this time, Phil.
Excellent. Okay, so we'll move into key takeaways. And we've got a list of a couple of questions that we sometimes get, so we may go through a few of those. Um, but we also we'll just start off with the key takeaways here. Over to you, Jess.
Thanks, Phil. So, in terms of things that we want you to remember from today's session or the most critical pieces, first, do continue to educate yourself on this topic and learn more. As we noted, the standards are evolving, how those get applied to technology evolve over time. So, it's good to come back to this information and sessions on this topic as you move forward in your work. Please do use the built-in accessibility tools that our different programs and software tools have, and utilize the tools that the University of Michigan is making available to our community to assist with remediation and making things accessible. Please also consider digital inclusion in your daily work. So we want to start focusing on making things born accessible. So having things be accessible from the start rather than having to go back and fix them later in remediation, because that's often more time consuming and frustrating. Some things to avoid moving forward. Please don't distribute digital content that you have not checked for accessibility. Run those checks, make the fixes that you can, and consult with our team or the ITS accessibility team for support if you don't know how to make the fix on your own. Please don't convert documents to PDF if you can avoid it. As we mentioned before, PDF is a very difficult format to work with in terms of applying accessibility features. So wherever you don't need to use PDF, you really shouldn't be. And then finally, don't make compliance decisions without consulting the Disability Equity Office. So if you're about to say that something is unreasonable or making things accessible to a certain degree is unreasonable, don't do that until you've consulted with us. Don't assume that exception criteria apply to your contents or your websites before you consult with us. We are here as a resource and we really do want you to utilize us.
Okay, so I think that we don't have any outstanding questions at this time. So um, I'm just going to quickly run through some of our end slides here for how you can reach out to DEO. Uh, so I'll turn it back to you, I think, Jess, if you'd like to talk
Good
through
to do
these.
that. Yep. Okay, so the first resource that we have in the end of the slide deck is a list of our upcoming events. Those are listed on the Happening at Michigan website. So there's a link there that will take you to our listing and a place where you can register for these upcoming sessions. Next, we have information about how to get in touch with the Disability Equity Office. So if you visit our website, there is a page that has information about accommodations and support, as well as support with digital accessibility. You will be redirected to a contact form that you can fill out to request any of the following: workplace accommodations, support with hiring accommodations, consultation with the Disability Equity Office staff. That includes the digital accessibility team. You can request ASL and CART services. You can request a digital accessibility review or consultation, and you can also request help with accommodations at sporting events, specifically getting accessible seating. You can also request training and workshops. And so we do have a training request form. It is also our barrier request form. So please just make sure you select the right options from the drop-down menu. But you can request training on any of our regular topics, as well as topics that we don't typically cover. And we'll get back in touch with you to figure out what we can do and how we can customize our content to the group that you want to bring us in to do more learning and education with. And then, as I mentioned, that training form also functions right now as our reporting barriers to access form. So again, select the right option from the dropdown, and then you will be prompted to input information about accessibility barriers on campus. And that is both in our physical environment as well as our digital environment. So if you're encountering digital accessibility areas or barriers, this is the place that you want to report those. And then Phil and our team will address those. And then finally, you may be prompted when you are hired at the University of Michigan or periodically as a part of your employment at the University of Michigan to voluntarily self-identify as having a disability. You can update this information at any time through Wolverine Access by clicking on Employee Self-Service and going to Campus Personal Information and then selecting your disability status. And we just wanted to reassure you that this information does not get shared with supervisors. It's not a way of disclosing to campus that you have a disability. This information is protected and it's just used for reporting purposes to the federal government to make sure that we are meeting expectations for the way that we hire in a non-discriminatory way. And then finally, we do have more learning opportunities from the Disability Equity Office. So we have a list of resources you can access on our website. We have our YouTube channel where you can watch recordings of our trainings, webinars, and presentations. We have that event list on Happening at Michigan. And we also have a newsletter, which we would love for you to sign up for because we do announce our events like this. And we also have really great tips and information that come out once a month in that. So please utilize these links to access these resources. And I think that might be it. So thank you so much for joining us today for Title II and U. We sincerely hope to see you at upcoming events, including at the National Disability Employment Awareness Month. We've started programming now, but that is officially in October. Phil, did you have any last words for the group?
No, thank you so much, everyone. Thank you to our access team and for everyone here in DEO behind the scenes making the event run. So appreciate everyone joining us, and we hope to see you at some of our NDEAM events throughout September and October. Thanks, everyone.